Hi, I am Abhilasha Nautiyal and I practice intellectual property law before the Delhi High Court. Today we will talk about the module on remedies in trademark law. In this module, we will discuss both civil, criminal remedies that are available to a right holder. In addition to these, we will also briefly touch on border enforcement mechanisms that are available to a right holder. We will now start with civil remedies that are available to a right holder. Section 135 of the Trademarks Act lists down the kind of remedies that are available. It first talks of an injunction. The second remedy is damages. Third is accounts of profit. Fourth is delivery up. In addition to these reliefs, Section 135 talks of ex parte injunctions or other interlocutory orders for three reliefs. These reliefs include discovery of documents, search and seizure preservation orders, and restraining the defendant from disposing of assets. Now, these three interim reliefs also have unique names. The first, discovery of documents, is also known as a Norwich Pharmacal order in certain cases, especially when discovery is sought from parties that are actually not pleaded in the suit. The second interim relief for preservation and search and seizure orders are known as ante pillar orders. And the third interim relief, which talks of freezing the defendant's assets, are known as Mariva injunctions. We will get to the interim injunction and the other interlocutory reliefs in a bit, but before we get there, we will start with permanent reliefs that a right holder may explore. We will start with injunctions. Now, injunctions are court orders that may direct a party to do something or not to do something. An order that directs a party not to do something is known as a prohibitory injunction, and an order that directs a party to do something is known as a mandatory injunction. Let's understand this by way of an example. Let's take the example of Nike and its swoosh logo. Tomorrow, if there is a party, say a party by the name M Brands, who is making counterfeits of Nike products and is misusing the swoosh logo. In such a case, what reliefs do you think is Nike looking at? It is of course looking to stop this party from doing something. And one of the reliefs that Nike would claim is a prohibitory injunction. The second kind of relief that right holders seek is damages. Now, damages are essentially fall in two broad categories: compensatory damages and punitive damages. We will first talk about compensatory damages. Compensatory damages basically try to put the plaintiff in the position that it was had the defendant not engaged in the infringing activities. Now, compensatory damages are the kind of damages that try to make the plaintiff whole again. By this I mean that the plaintiff is compensated for the losses that it has suffered due to the defendant's activities. There are at least three ways of calculating compensatory damages. First is that the plaintiff may assert and quantify the loss it has suffered due to the infringing activities of the defendants. Please remember that the quantum here is directly related to the infringing activities and not other activities that the parties may engage into. The second way of quantifying compensatory damages is based on the profits made by the defendant. Interestingly, this concept of profits of the defendant is also known as rendition of accounts, to which we will get in a bit. The third way of calculating compensatory damages is on the basis of a reasonable royalty. Now, a reasonable royalty test is one where it is seen that what would in ordinary circumstances be the royalty, that if the defendant were a willing licensee of the plaintiff's rights, what would be the amount that the defendant would actually pay the plaintiff as a royalty. We will now talk about punitive damages. Punitive damages are in addition to compensatory damages and are awarded to deter the infringing acts of a defendant. punitive damages are most commonly awarded against habitual and repeated offenders. In the case of Time versus Lokesh Srivastav and another, the Delhi High Court elaborated on the concept of punitive damages and explained the difference between both compensatory and punitive damages. Now, in this case, Time magazine had sued a party in India for infringement of its logos, which were both Time, Time Asia, and the red border of the Time magazine. The court held the award of compensatory damages to a plaintiff is aimed at compensating him for the loss suffered by him, whereas punitive damages are aimed at deterring a wrongdoer and the like-minded from indulging in such lawful activities. Whenever an action has criminal propensity, also the punitive damages are clearly called for. Therefore, punitive damages are awarded to set a standard to deter people from engaging in activities that the court wants to discourage. Now, under section 135 of the Trademarks Act, on the one hand, it does list out the reliefs that a party is entitled to, and on the other hand, it lists out certain exceptions to some of these reliefs. Section 135 clause 3 of the Trademarks Act provides exceptions to damages. It lists a few cases where damages may not be awarded to the right holder, even where the right holder is able to prove that the defendant has violated its trademark rights. Now, these cases include cases of infringement of a certification mark or a collective mark, or where the defendant is able to prove that infringement or passing off was not willful. Now, what do we mean by willful? Here, the defendant will have to satisfy at least two things. A, that the defendant was not aware or had no reasonable grounds to believe that it was violating the plaintiff's rights. B, as soon as the defendant became aware of the plaintiff's rights, it ceased use of the plaintiff's trademarks. Please remember that both of these factors have to be satisfied before the defendant can plead that it should not be liable for damages on account of its conduct. We will now come to the next relief, which is account of profit. We had briefly touched on this relief in our discussion on compensatory damages. You may recall that compensatory damages try to make the plaintiff whole, and we discussed at least three ways of doing that. First was plaintiff's losses suffered due to the acts of the defendant. We also discussed a reasonable royalty model, and the third factor that we discussed was the profits of the defendant. Accounts of profit refers to the last factor. When a defendant is violating the plaintiff's trademark, it generates revenue by such use, and it is believed that the revenue generated by the defendant from its infringing activities is actually attributable to the plaintiff, and hence the plaintiff is entitled to the accounts of profits of the defendant, which the defendant should produce, and the plaintiff may recover the same. In certain cases, at least in the Trademarks Act, you would have noticed the word "or" between the reliefs damages and accounts of profits. A plaintiff has to elect between these two reliefs. The reason for this election is that most commonly there would be a complete overlap between the plaintiff's losses and the defendant's profits. Because there is a complete overlap, a plaintiff should not be entitled to recover twice the amount than what it is actually entitled to, hence the election. However, it may be noted that in some cases there may not be a complete overlap. What about loss to intangible value of a trademark that may be a result of the defendant's activities? Now, in such cases, there may not be a complete overlap between the plaintiff's loss and the defendant's profits. We will now talk of cases where defendants do not enter appearance before court. What happens then? Let's go back to a Nike example. Nike files a lawsuit for trademark infringement and passing off against a party that's counterfeiting its swoosh. The court issues notice to the defendant, but the defendant never shows up in court. can Nike still recover damages? What is the basis for Nike to recover damages where the defendant has evaded court service? Now, courts have taken serious cognizance of such acts. In the case of Microsoft Corporation versus Rajendra Pawar, the Delhi High Court said, perhaps it has now become a trend of sorts, especially in matters pertaining to passing off, for the defendant party to evade court proceedings in a systematic attempt to jettison the relief sought by the plaintiff. Such flagrancy of the defendant's conduct is strictly deprecatory, and those who recklessly indulge in such shenanigans must do so at their peril. So, courts are increasingly granting punitive and compensatory damages even in cases where the defendants are not forthcoming with appearing in court or cooperating in the proceedings. We will now come to the final relief that we will discuss in the nature of permanent relief, and this is the relief of delivery up. Now, once a plaintiff files a suit, they get the permanent relief of an injunction. They also get a permanent relief of, say, damages. What happens to the defendant's inventory? What happens to the stock that the defendant has stored with respect to the infringing trademark? In that case, it's the relief of delivery up that the plaintiff would like to enforce. Delivery up is when the court would direct the defendant to either hand over the infringing products, which would include advertisements, packaging materials, other paraphernalia that the defendant would have in its possession, to either the court or the plaintiffs. Now, what happens after delivery up takes place? In most cases, the infringing goods are destroyed under court supervision. But in a very interesting case before the Delhi High Court of Luxottica versus Muni, the defendant agreed to donate several hundred pieces of unbranded sunglasses to a blind school which were earlier infringing. We will now talk about interim reliefs that a plaintiff may claim in a trademark suit. Why do we need to consider interim reliefs when we've already discussed permanent reliefs? As you may know, once a lawsuit is filed, it has to go through the entire process of adjudication, including trial, before judgment in the suit is pronounced. This may take a few years depending on the jurisdiction in which the suit is filed. Since the judgment in a suit takes at least a few years, plaintiffs would like to have some relief that would protect their interests during the pendency of the suit. Hence, interim reliefs are sought. Now, we will discuss at least 4 kinds of interim reliefs that also find mention in section 135 of the Trademarks Act. Let's go back to section 135 of the Trademarks Act. You would recall we spoke about ex parte injunctions or any interlocutory order for discovery of documents, preservation of infringing goods, documents or other evidence which are related to the subject matter of the suit, restraining the defendant from disposing of or dealing with his assets in a manner which may adversely affect the plaintiff's ability to recover damages, costs or other pecuniary remedies which may be finally awarded to the plaintiff. We will now discuss each of these interim reliefs in detail. We will start with interim injunctions. What normally happens in a court is, once a lawsuit is filed, plaintiffs try to seek ex parte injunctions on the very date the lawsuit is first listed. These injunctions are called ex parte because they are sought and granted in the absence of the other party, when the defendant is absent before the court. For grant of ex parte injunctions, the standards set are usually very high, and these injunctions can be easily set aside under Order 39 Rule 4 if the plaintiff has concealed or misrepresented in any manner before the court. For grant of interim injunctions, the Supreme Court has laid down at least 3 factors that must be considered. First is the factor of a prima facie case. Second is the factor of irreparable harm and injury to the plaintiff. And the last factor is balance of convenience. We will first talk about prima facie case. By prima facie case, it is meant that the plaintiff has to establish at the interlocutory stage that it has a good case on merits. Now, this may be proved by relying on documents such as plaintiff's trademark registrations, documents showing long use of the trademark by the plaintiff, court orders recognizing and enforcing the plaintiff's rights, and also documents to show the infringing activities of the defendant. Once a party is able to establish prima facie case, it has to also satisfy the other two conditions. In the case of mandatory injunctions as opposed to prohibitory injunctions, the standard is of a strong prima facie case as opposed to a prima facie case. We will now talk about the second requirement, which is irreparable harm and injury. The plaintiff has to show to the court that the absence of an injunction will cause irreparable harm to the plaintiff, which may not be compensated by way of damages. In trademark cases, this is usually done by showing harm to the reputation and other intangible assets of the plaintiff. The last factor is the balance of convenience, which is actually a weighing scale by which the court determines the impact of the absence of injunction on the plaintiff on one hand and the impact of an injunction on the defendant on the other hand. And once it weighs the two factors and concludes whoever the balance of convenience is in favor of, this factor is determined accordingly. The second interim relief that we will talk of today are called ante and pillar orders. Such orders also find mention in section 135 of the Trademarks Act as orders that help preserve evidence. What happens when a suit is filed? The defendant is made aware of the suit by the court. The defendant then has the option of actually destroying the evidence that may put it in jeopardy. Therefore, to avoid a situation where the defendant would actually destroy the infringing products, such orders are passed. These orders derive their name from an old English case called the ante and pillar case. Under the Indian statute, the Code of Civil Procedure under Order 26 provides for mechanisms by which a local commissioner may be appointed to visit the defendant's premises and inspect what goods or services the defendant is offering there. In practice, a local commissioner is appointed who visits the defendant's premises and makes a noting of everything that is present at the defendant's compound. Once such noting is made, the local commissioner is usually empowered to take photographs, to record proceedings in other ways as well. Practically, once the local commissioner makes his report, the goods are handed back to the defendant on superdari, which means that the defendant cannot dispose of those goods and is simply a custodian of the goods that were seized by the local commissioner. The defendant is duty bound to produce those goods as and when directed by the court. We will now talk of the third interim relief of Mariva injunctions. Again, the name is derived from an old case. Mariva injunctions also find mention in section 135 of the Trademarks Act as injunctions that are directed towards freezing the defendant's assets. In a recent case of World Wrestling Entertainment versus Vinayak Sondhi, the Delhi High Court froze the defendant's bank accounts. In this case, the defendant was operating an online portal through which it was selling infringing WWE merchandise. The last interim relief that we will talk of today are called discovery orders, which also find mention in section 135 of the Trademarks Act. Now, while discovery is accepted practice in all civil suits, there is a special kind of discovery process that is being recognized in intellectual property matters. These are called the Norwick Pharmacal orders. What is unique about Norwick Pharmacal orders? Now, these orders are especially helpful when information that would help the plaintiff establish infringement are not within its reach. For example, records of the customs. We have now concluded the section on civil remedies. We will now talk about criminal remedies. But before we proceed with criminal remedies in the Trademarks Act, let us understand the meaning of a few key terms. The first term defined in the Trademarks Act, which is of relevance here, is the meaning of applying a trademark. Section 101 of the Trademarks Act defines what is the meaning of applying a mark or trade description to goods or services. This section provides that applying a mark means applying it to goods themselves or use it in relation to services, or applying to any package of the goods, or placing, enclosing or annexing any goods which are sold, exposed for sale or had in possession for sale or for any purpose of trade or manufacture with any package or other thing to which a trademark or trade description has been applied. As you would have noticed, applying a mark includes both applying it on the goods themselves or services, or applying it to any packaging pertaining to the same, and also includes placing those physical goods at any location. This also includes use of a trademark or trade description in any manner that will reasonably cause people to believe that those specific goods or services are sold under that trademark. It also includes relation to the goods or services, a trademark or trade description, sign, advertisement, catalogue which is delivered to a person pursuant to a request or order made by reference to the trademark or trade description in question. A trademark or trade description is also deemed to be applied to goods when it is actually physically woven in, impressed on or otherwise worked on or annexed to the goods or products or their packages. The second meaning that we need to understand is falsification of a trademark. Under section 102 of the Trademarks Act, it is described when a person is deemed to falsify a trademark, and this includes when a person without the assent of the proprietor of the trademark makes the trademark or a deceptively similar mark. Secondly, when a person falsifies any genuine trademark by altering it, adding or otherwise. A person is also deemed to falsely apply a trademark when such person without the consent of the proprietor of the trademark applies such trademark or a deceptively similar mark to goods or services or any package containing goods, and uses any package bearing a mark which is identical or deceptively similar to the trademark of the proprietor for the purpose of packing, filling, wrapping goods or services other than those which are genuine products of the proprietor. Prosecution for falsifying a trademark or false application of a trademark, the burden of proving that the accused had consent of the proprietor lies on the accused. We will now talk about the offences that are provided in the Trademarks Act. Section 103 of the Trademarks Act makes the following acts punishable. First, falsification of a trademark. Second, falsely applying to goods or services any trademark. Making, disposing of or having in possession any die, block, machine, etc. being used for falsifying a trademark. Applying any false trade description to goods or services. Applying to any goods or services any indication in violation of section 139 of the Trademarks Act. Tampering with, altering or removing an indication of origin which has been directed under section 139 of the Trademarks Act, and causing any of these acts to be done. Unless one proves that he or she acted without intent to defraud, punishment for these acts is a term which shall be not less than 6 months and which may be extended to 3 years, and with a fine which may not be less than 50,000 rupees but which may extend to rupees 2 lakhs. The court may, for adequate and special reasons that it has to mention in its judgment, impose a sentence of imprisonment for a term less than 6 months or a fine less than 50,000 rupees. There are certain exceptions to this penal provision. Those exceptions are provided in section 112 of the Trademarks Act. When a person accused of an offence under section 103 proves that in the ordinary course of his business, he is employed on behalf of other persons to apply trademarks or trade descriptions to make dies, blocks, and that in the case which is the subject of the charge, he was so employed, he was not interested in the goods or other things by way of profit or commission dependent on the sale of such goods, and that having all reasonable precautions against committing the offence charged, he had at the time of commission of the alleged offence no reason to suspect genuineness of the trademark or trade description, and that on demand made by or on behalf of the prosecutor, he gave all information in his power with respect to the persons on whose behalf the trademark or trade description was applied. Such person shall be acquitted. So, to get an acquittal for an offence under section 112, the accused will have to prove 4 things. First, that in the ordinary course of business, he was employed by someone for doing the infringing act. Second, he had no interest in the sale of those goods. Third, he had no reasonable reason to believe that the acts were infringing. And fourth, that he has fully cooperated with the prosecutor and provided all information about the person on whose instructions he had committed those acts. We will now cover the second penal provision in the Trademarks Act, which provides for penalty for selling goods or providing services to which false trademark or false trade description is applied. You may recall that section 103 dealt with actually falsifying trademarks or falsely applying trademarks, while section 104 deals with penalty for selling or providing services to which false trademarks or trade descriptions are applied. Under section 104, a person who sells, lets or hires any infringing goods is liable for infringing the same, unless such person can prove that he had no reason to suspect the genuineness of the trademark or trade description, or he gave all information in his power with respect to the person from whom he obtained such goods or services, or that he had otherwise acted innocently. Such person shall be punishable with a term which shall be not less than 6 months, but which may extend to 3 years, and with fine which shall not be less than 50,000 rupees, but may extend to rupees 3 lakhs. As in the case of section 103, a judge has powers to reduce the sentence beyond the minimum prescribed and reduce the fine beyond the minimum prescribed, subject to recordal of reasons in the judgment. Now, section 120 of the Trademarks Act also punishes abatement of offences under the Act. We have now concluded the section on criminal remedies. We will briefly touch of a third kind of remedy that is available to right holders in India. These are the border control measures. Under the Intellectual Property Rights Imported Goods Enforcement Rules 2007, a right holder can record or register its rights with the customs. The customs in return will identify infringing goods or suspicious goods and inform the right holder to take action. We will now summarize the module for today. We started with civil remedies that are available to a right holder. We discussed both permanent reliefs and interim reliefs. In permanent reliefs, we discussed injunctions, damages, accounts of profit, delivery up. In interim reliefs, we discussed interim and ex parte injunctions. We then spoke about ante and pillar orders, Mariva injunctions and discovery orders, including Norvik Pharmacal orders. We then discussed criminal remedies under trademark law and discussed the meaning of falsification, falsely applying trademarks. We then discussed provisions of Section 103, Section 104 of the Trademarks Act, and whether abetment of infringing acts is also liable in India. And we concluded with a brief discussion on border enforcement mechanisms that a plaintiff may use to enforce its trademark rights in India. Thank you.